Hi there, my name is Jonathan Ginsberg. I'm a Social Security Disability attorney. And today I'd like to answer the question, what does it mean if the judge has no questions for the vocational witness at your hearing? And I get this question a lot. It's kind of odd to me why this question gets asked so many times, but it does. And I guess people go to the hearing and they have this vocational witness there and they want to know, what does it mean that the judge said this? Or what does it mean that the judge said that? Or what does it mean that the judge asked no questions at all? Generally speaking, if the judge has no questions for the vocational witness, that's probably a pretty good sign. That probably means that your case on its face medically was really, really strong, that your case either meets a listing or meets a grid rule, and the judge does not have to get into the nitty-gritty of vocational issues. So generally speaking, if there's no questions of the vocational witness, that's a good thing. The judge realizes a vocational witness is supposed to be an expert about jobs, and this could be based on placement work in the past, or it could be theoretical work, understanding the various publications about jobs in the national economy. And so the vocational witness has expertise about that and can apply that expertise if the judge asks questions about medical issues. So if the judge says, if this person can't sit for more than 20 minutes at a time, what does that mean for this type of job, a cashier job or a food worker job? And the vocational witness can answer that. The judge is not allowed to substitute his or her own understanding of work issues or work requirements for the vocational witness. So that's why if the judge has no questions and the judge issues a decision saying, I think this person could work as a cashier or a parking lot attendant, that would be an appealable decision because the judge can't substitute his or her opinion for a vocational witness. Now, there are a few times, and I'd say probably 10 or 15% of the time, when the judge has no questions for the vocational witness, and it's not a good sign. And that would be your case is really, really weak, that there's not even evidence of a severe impairment, nothing significant going on in terms of the impairment. Social Security has something called a 5-step sequential evaluation process. I know they make a simple concept complicated, but one of the questions there is, are you working? Second step is, do you have a severe impairment? Well, if you're working and you're working full-time, the judge doesn't have to even get to the question about the nature of your impairments because you're by definition not disabled. If you don't have a severe impairment, if there's really nothing in the medical record to suggest a significant medical problem, that would be, again, a reason the judge could deny you what they call step 2 denial. It doesn't happen a lot, but it could happen. And again, my experience has been that judges would rather just ask 1 or 2 questions of the vocational witness after taking testimony, have very, very, very mild limitations in the question, and then based on the answer to that question, the judge would deny you on that basis. So normally, no questions is a good sign. Every once in a while, it's not a good sign, but I'd say 10-15% of the time at most. But usually, if there's no questions, that's a good sign. And I think by the same token, if the judge has only 1 question of the vocational witness, and the answer is, Your Honor, there are no jobs I can think of that would fit this profile, that's also a good sign. That means that there's only 1 vocational consideration to be thought about or to be included in the judge's evaluation, and that 1 consideration is that there are no jobs. So that's what you can read from some of the vocational witness testimony or the questions asked by the judge. And again, not an exact science, but that's been my experience over 25 plus years. Hope you found this helpful. If you did, please give it a thumbs up on YouTube, like it on Facebook, subscribe to my YouTube channel and my Facebook page, and visit my website at ssdanswers.com. You can download my free Secrets to Winning Disability Survival Kit. You can ask for a case evaluation. If you're not represented, you can ask for a case evaluation. And if I can do anything for you, please let me know. My name again is Jonathan Ginsberg, and I do wish you the best. Thanks a lot. Hi, this is Jonathan Ginsberg, and I hope you found this video helpful. If you'd like to know more about how to win your Social Security disability case, I'd like to invite you to download my Secrets to Getting Approved Early Survival Kit that I created just for people like you. Currently, I'm making the survival kit available at no cost, and I encourage you to grab your copy now. Some of the topics I cover include, how do I know if I have a case? Is it the right time for me to file my claim? 9 common mistakes that can doom your case. The 3 must-have arguments you use to win your case. And a topic that every disability claimant wants to know, how to avoid trick questions from the judge. If you or a loved one need to win Social Security disability benefits, you'll find the Survival Kit essential reading. Download your Survival Kit right now and at no cost. Just visit ssdanswers.com/survival and sign up. It's that easy. Please act now. And as always, I wish you the best.